Sorry, Khab. This time I will be talking more onto the basic characteristics of arbitration, means the salient features. I'll be covering up overall, but what is the uniqueness of arbitration? So in arbitration, the first thing which is very important is the consent. The consent of the parties is very important because the consent of the parties gives the very power to the arbitrators. So if the parties don't agree on particular issue or if the parties don't sign an agreement, arbitrators will have no powers to arbitrate anything. And second is that even if the arbitrators are given power by the parties, but that power is very limited because the arbitrators will have to work within the scope of the agreement, whatever they have agreed, whatever rules they have come up, they have to work within that rule. They cannot go beyond what has been agreed by the parties. So this is the second important under consent. Then the fourth is that the parties will always try to express their consent in the form of the arbitration agreement. And sometimes they will include this consent in the form of a clause in the contract document. So this is how the valid consent will be considered, which will give ultimately power to the arbitrators. So that's why the consent is very important, and that consent has to be in a written form. It cannot be simply a verbal, because since the arbitration will give an award which is enforceable like a judgment only. So there has to be a documentary evidence to prove how powers are given. So without any valid document, without any agreement, that people cannot simply give consent through verbal. So that's why the written agreement is very important. So, but other thing, even if they don't initially plan for settling the dispute through the arbitration, and there is no arbitration clause as such, or there is no the arbitration agreement to give arbitrator to arbitrate the matters. But later on, after the problem has come up, if the parties feel that they still need to do arbitration, so that they can do later on, so which is called the submission agreement, so that they'll make a separate agreement, particularly focusing onto that point. So this is a consent. So without consent, nothing will work out. So arbitrators will have no power at all. So this is the first factor or first characteristics of arbitration. Then second is non-governmental decision makers. Now I'm trying to come to the arbitrators. Who are they? So arbitrators are actually a private citizen, a businessman, a private lawyer, a retired judge, and they don't really belong to the formal organization of the government. So they will be a private citizen or doing their own business. But people who are known in the society, people who have so much of caliber, people who have so much of respect in the society, people who had so much of experience in the society. So these people, great personalities, reliable. So they become the arbitrators. And compared to the judges, arbitrators will have, actually they'll have less concern. They will not bother on the public policy, public interest, all that thing. They are not bothered in that. Because for them, they have to focus only on to one issue. One issue is that what is the problem within the parties, what they have signed between them, and what is the problem. So they will focus more onto the interest and issue of their parties. So about public policy and all things, they'll not do, because they are not supposed to go beyond what parties has given them, the assignment which they are supposed to go through. So this is a vast difference between the judge. For a judge, you have to look for the public interest, for the public policy. There are so many considerations before they pass the judgment. So that's why, but here it will be only based on what the parties is looking for and what is right for them between two parties. This is very important. And for judges, it is almost necessary for a person to have a law degree and has to be a lawyer initially, then has to groom up, and only the judges who has done law and all will become a proper judge as such. But for an arbitrator, it is not necessarily to be a lawyer as such. The arbitrator could be anybody having a lot of experiences. and the arbitrators will depend on to the nature of the dispute. If the nature of the dispute is all about commercial activities, person who has been doing business, commercial activities and all, they will get into it. And people who are more into, like supposing like IT, if there is an IT issue, person who has been doing IT for many years, so they will be then employed or engaged as arbitrator. So the arbitrator's role will change to based on the nature of the dispute. So this is the main difference again between judges and the arbitrators. And when there is 3 arbitrators, as I already said, then each party will choose their own arbitrator, and these 2 arbitrators who are representing the claimant and the respondent, they will appoint a 3rd arbitrator who will be the chairperson of the arbitral tribunal. So arbitrators are, of course, like same like arbitrators, even for a judge also, he or she has to be independent and impartial. But in arbitration, I think this independent and impartiality is very sensitive because there are only 2 parties, and these 2, the arbitrators or the 3rd arbitrator, since they are working in very close proximity and with certain fixed rules, regulations, and the terms and conditions, the independent and impartiality is very sensitive. So that's why the arbitrators will have to be very, very careful, and every small things will become very sensitive in that issue. So that's why independent and impartiality is one of the important factors in arbitration. So because even though we always say that when the arbitrators are appointed by their parties, it doesn't mean that parties cannot challenge them. Parties can challenge against their own arbitrators before the arbitration institution or even before the court sometimes. If the arbitrator breached these 2 important factors, not being independent and not being impartial, even his own party can challenge him before the court or the institution, particular institution. The arbitrator should always be perceived as, actually they should be same like a judge. There is not much difference. They must be ill-tempered, because for a judge it is like in a mass and there are so many people involved. But in arbitration it is in a closed room. It is in a very small room, and everything becomes very sensitive. So they must be even-tempered. We cannot be temperamental, and they must be thoughtful. Then fair-minded is very important, and most important thing is the reasonableness. So if you don't qualify to act within these means, then your own party, the person who has appointed you, can challenge you. When they challenge their own arbitrator, then that will unnecessarily delay the arbitration procedure. So when arbitration procedures are delayed, then there is no point in just arbitrating matters for arbitration. If it takes same length of time, like being the court, the case being processed before the court of law. So that's where the arbitrators must be very sensitive, very legible. They should be impartial, and also they have to be very selective in whatever they say. It's very important. So these are all about the private parties being involved as arbitrators. And third is the final and binding of the award, same like the judgment of the court, is one of the important features or one of the important salient features of the arbitration. Unlike mediation and negotiation, in the arbitration, the biggest advantage is about the final result. The final result of the arbitration. So ultimately, the award will be passed, and there is a certainty of a result or certainty of an outcome in the arbitration. And that's why for arbitration, it has the same value, and it has the same weight and same sanctity as a judgment. So once the arbitration is over, and when the arbitration award is being passed, the parties will have to be bound by it. The parties have to honor that one, because it is their very decision to do the arbitration in the mode which they have selected by themselves. But at sometimes the parties can also challenge the arbitration award. They can challenge the arbitration award, but it has to be done before it has become final and binding. Because in between, once the arbitration is passed, they are given certain time to do correction, or they are also given time to submit any additional point that they have left. If you want to do any correction to the award and all, they are given enough time. So for that, in that period or in that range of time, people can challenge the arbitration, and then accordingly a correction will be done. So otherwise, if we don't allow that one, then there will be unfair and impartiality and all. But once the award is being passed and has become final and binding, then to appeal further on that, there is a very less chance of being appealed against the award after that. Because if we do that one, then if people are made to challenge against the award after it has become final and binding before the court of law, then there will be no end to it. It will become very similar to filing a case before the court of law. So that's where parties, when they want to challenge on the arbitration award, they cannot challenge on the merit. Even if the arbitrators had made a mistake of law, even if there is wrong interpretation of the law, or even if there is a mistake of facts, even if there is mistake of facts in the award, people cannot challenge that. The very reason is that when the people are making a submission before the tribunal, they are given all the chances. If there is a mistake of fact, they must submit then and there, or before the arbitral award has become final and binding. They must raise the point before it becomes final and binding. So since they are given all the chances to submit everything, and since even the way the arbitration is done, it's all based on their agreement, it is all based on their rules and regulation, it is based on the laws which they have chosen themselves, it's all their choice. So that's why, since they have all the chances to do correction or everything, later on they cannot challenge. So that's why there has to be an end to a particular procedure. So that's why even on the merit of the facts and on the mistake of law, means wrong interpretation, there will be no appeal on that. So the appeal will be in a very limited ground. Other one is that if the arbitration is against the public policy or is against the national policy or something like that, and if it's going to affect the larger community because of that, then in that case the judge can review and that see that whether that could be changed or not. Other than that, because the very objective and purpose of the arbitration is to cut costs and also to save the time. But if you allow on people to appeal on the arbitration, then it will be always better to start it only as a case. Then you will be not saving time. You will be also then wasting time in that case. So that's why for an arbitration, though it is very fast, speedy, time saving and all, but if the parties are not very mindful of using it in a very intelligent way, in a very desired and within the purview of the law, if they fail to do that one, then at the end of the day, they may not get satisfaction out of it. So that's why we must take advantage of it in the best way and possible means. And also when you choose the arbitrator, we have to be very careful, because once you've chosen the arbitrator and going against the arbitrator, we will only waste time. So for that, once you have chosen the arbitrator, means you must always trust him, so that he will also do his best in all. And that way, I think everything has to be transparent. Even one particular arbitrator, if he wants to discuss with the respondent, he cannot do it on private. That has to be announced within the session, and they must discuss. And I think even if you do a discussion, other party has to inform. Then the other arbitrator has to be informed. So everybody should know what we are doing. So if something is done in private, there will be something problem, and that will later on lead to a problem. So for that way, the job of an arbitrator is a very matter of big honor, but at the same time, he or she has a bigger responsibility, because it will be very sensitive. So for that, but if all work as per the view, as per the objective, as per the principle, as per the expectations and all, then all are going to benefit a lot out of it. So that's why the salient features and this certain uniqueness of the arbitration is very important. These factors I think you have to keep in mind, not only as arbitrator, but even for the parties, how to make use of it. We cannot simply use arbitration simply for the sake of buying time. If you do it for sake of buying time, later on we cannot challenge the arbitration, and then we cannot even raise the issue before the court of law, and that way, it might also strain the relationship. For that, the arbitration is a very noble process. It's a very dynamic process for saving time, and it is very good for the parties, especially people who are doing business, because we have no time to go to the court and wait for long queue and years we spend, and then we have no choice. In arbitration, you have a choice to choose which arbitrator you want, who will be best to you. But in the court of law, we cannot choose judge. We can't say, I want this judge, I want this judge, I want that judge. No, it will all go into the time, the roster. So that way, there is no choice. And even in arbitration, then sometimes we can also save time, and if you agree to each other, we can always agree and then later on again use the arbitrators to sign it and pass an award. So that's why these three factors, which is very important and very unique in arbitration, which you should know and take advantage of it for the better future of all the people who are doing business, and also good for all the arbitrators. So that way we the Thai Arbitration Institution, we have very good arbitrators who had so much of experience and so much of knowledge, who has done so many arbitrations. Now even we are going to celebrate 30 years of our service to the nation. So we have been doing arbitration for the last 30 years. So with that, I hope that all of you will turn to us and then seek our assistance. Our service is always for you all. And we are also coming up with many new dynamic due process and all, and also to solve not only through the real arbitration on ground, but online arbitration we are encouraging. So that way we will keep on updating any new program that we have here. I have also announced last time about the arbitration with holiday package, like Smile Thailand or something. You can do arbitration based on this program, where we can come to Thailand for your holiday package and do your job and then go back. So that way, we get gain. We can get a lot of gain out of it. So with this today, I'll end with this short talk. And next time, I will focus into other important factors. Thank you.